I'm Loni Allen, and next to me is
Dianah Marr. We both work in the Education Department as Education Specialists at Parents Helping Parents here in San Jose, California. Next slide.
Parents Helping Parents is a federally funded parent training and information center. Our PTI covers San Joaquin, San Mateo, Santa Clara, and Santa Cruz counties in California. Each state has at least one PTI, but because California is so large, we have many. You can call PHP to be referred to the one in your area. Dianah is going to describe the services that we provide.
At PHP, we have resources and supports for families and professionals alike, including a lending library, family and community resources, information and support staff, mentor support parents, support groups, education department trainings, one-on-one support, and phone support, iTech, support training and information about assistive technology, and support groups.
We're glad you could take the time to join us today to learn about Section 504 and the Public School District Responsibility. We plan to briefly review the legal background, evaluation process, plans and services, and also your procedural safeguards. We'd like this webinar to be interactive, so please write your questions in the message box as the training goes along. We're going to take one break about halfway through the training to answer questions briefly, and then we'll answer some additional questions at the end of the training. Next slide.
The term Section 504 refers to a specific part of the Rehabilitation Act of 1973. A broad national civil rights law that prohibits discrimination against people with disabilities by any program or activity that receives federal funding. So this includes all public schools and any private schools that receive federal funds.
In addition to protecting school-age children, Section 504 also ensures non-discrimination of people with disabilities of all ages in other federally funded programs, such as post-secondary education, healthcare, and housing. The complete Section 504 regulations can be found on the link on the slide. Next slide. So what does Section 504 say? Well, this slide includes the exact language found in the federal statute that's the basis for Section 504 protections for students with disabilities. Quote, no otherwise qualified individual with a disability in the United States shall, solely by the reason of her or his disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance, end quote. The phrase, no otherwise qualified individual, means that a person must meet all other requirements for participating in a program in order to be protected against discrimination on the basis of his or her disability. Dianah, could you give us an example?
Sure. So let's say a parent of a 4-year-old with autism wanted to enroll him in their local public elementary school for kindergarten, and the local school denied the request. The parents wanted to file a discrimination complaint against the school for refusing to accept their child with a disability. However, since the child was only 4, he did not meet the program requirements, which required kindergartners to be at least 5 years old at the start of the school year. Therefore, the child did not meet the definition of otherwise qualified because he was refused because of his age, and so was not protected under Section 504 in this case.
Thanks, Dianah. That's a good example. And next slide. When people think about educating students with disabilities, the first thing that may come to mind is the Individuals with Disabilities Education Act, also known as IDEA. Although students can receive accommodations, related services, and special education under both Section 504 and IDEA, the two laws vary in a number of important ways that will be explained further in our presentation. Some of the key legal differences, and if you could explain those, Dianah?
Sure. Thanks, Loni. So IDEA is a federal statute that provides funds to state special education programs on the condition that the specific requirements outlined in IDEA are followed. Section 504 prohibits discrimination on the basis of disability, but does not provide any type of funding. Entities that receive federal financial assistance must agree to comply with Section 504 as a condition of receiving funding. So, Loni, can you explain who ensures the schools to comply with these laws?
Sure. It's the Office for Civil Rights that enforces schools' compliance with Section 504. The state education agency enforces the district's compliance with IDEA with regard to individual students. So Dianah, what happens when a parent changes their mind about eligibility for Section 504?
Well, you should know that if a parent chooses to revoke or remove their consent to the provision of special education services for the child under IDEA, the student may still be eligible to receive services under Section 504. In that case, the parent would need to request a Section 504 evaluation, and best practice is to do that in writing. Many students with disabilities are protected under both IDEA and Section 504, and districts may comply with certain 504 requirements by following IDEA procedures. Although all students who receive special education services under IDEA are protected by Section 504, not all students protected under 504 qualify for IDEA services. Also, if a student is receiving special education services under IDEA, there is no reason to also have a separately written 504 plan. Next slide.
This slide has a diagram with 4 concentric circles, different colors. And the diagram helps explain the interaction between the Individuals with Disabilities Act and Section 504 of the Rehabilitation Act and the student population as a whole. Note the size of the circles is not meant to proportionally represent the size of the student population that fits into each of the categories. The bright yellow circle in the background represents all students in a school district, and the next largest gray circle represents all students with disabilities or impairments. The next light circle, that light purple circle, indicates the group of students who qualify to receive Section 504 services, and the smallest red circle represents students eligible to receive services under IDEA or special education. To be eligible for services under IDEA, the child must be determined to meet one of the categories of eligibility included in the federal statute, and because of that disability, need special education or related services. This distinction is especially important for children with health-related disabilities who may need accommodations to allow medication, administration, etc., but may not be showing any academic impact of their disability.
That's right, Loni. So there are some important things to note in this diagram. You can see here, as we mentioned earlier, that not all students with disabilities or impairments qualify for services or protections under 504 or IDEA. We can also see that a medical diagnosis is not enough to determine eligibility.
Now we understand that a full evaluation must be conducted to determine the student's eligibility under Section 504 or IDEA. And we can also see that although not all students eligible under Section 504 qualify under IDEA, all students receiving special education services under IDEA do qualify for protection under Section 504.
Oh, Loni, one more thing. It's important to remember that the requirements under IDEA are more stringent than those for 504. Next slide.
This slide has a side-by-side comparison and a little bit of a chart comparing Section 504 to IDEA, and it'll help you understand the differences between Section 504 and IDEA. For example, what about money?
Yes. How about the money?
As you can see from the chart, Section 504 does not authorize any funding to states or school districts to provide services needed by students. IDEA, however, is a funding statute, which means that state and local educational agencies must comply with IDEA provisions in order to receive the funding. IDEA services are funded by a combination of state and federal funding.
And Loni, how are they different in regards to eligibility?
Well, the definition of an eligible child with a disability is different under Section 504 and IDEA. The IDEA eligibility criteria is more strict than Section 504.
So then, what about the requirement to evaluate, or I've also heard it called assessment?
Well, IDEA regulations are much more detailed regarding evaluations. In addition to the initial evaluation, reevaluations must occur every 3 years unless the parent and the school agree it's not necessary. Under Section 504, only periodic reevaluation is required. OCR, the Office for Civil Rights, has interpreted that to mean that reevaluation is required whenever there is to be a significant change in placement or level of service, including a termination of services.
Okay, I think we understand that. But what about FAPE, F-A-P-E, which stands for a free, appropriate public education?
Good question, Diana, because the definition of FAPE is different between the two laws. Under Section 504, it means that the needs of qualified students with disabilities are met as adequately as the needs of children without disabilities. The primary focus is on equal access. Under IDEA, FAPE means that students with disabilities receive an individualized education program that meets a student's unique needs, provides access to the general curriculum, meets grade level standards, and from which the child receives educational benefit. The inclusion of educational benefit is an especially important distinction between the two laws.
So does there have to be some sort of written plan, Loni?
Well, actually, no. A written plan is not required under Section 504 regulations, but OCR considers it to be best practice to ensure that all the parties understand what has been agreed to in order to ensure equal access to the student with a disability. Under IDEA, the Written Individualized Education Program, or IEP, is required.
I see in this chart that the Office for Civil Rights enforces schools' compliance with Section 504. The State Education Agency enforces districts' compliance with IDEA with regard to individual students. Next slide.
On this slide, there's a photo of a group of students in their classroom. And now a little bit of history. Prior to the enactment of the Americans with Disabilities Act Amendments Act, the U.S. Supreme Court decisions had begun to narrow the way that disability was defined. As of January 1st, 2009, the ADAAA regulations clarified that disability is to be interpreted broadly. Now the ADAAA and Section 504 are interpreted together, and because of this, the updated definition of disability in the ADAAA must be used when a student's eligibility is determined under Section 504. Click on the link on the slide to find out more about the Americans with Disabilities Act Amendments Act. Next slide. Section 504 defines disability as a person who, 1, has an impairment that, 2, substantially limits the student's ability to perform 3, one or more major life activities.
So Loni, does a student have to meet all 3?
Yes, good question, Diana. In order to qualify as a person with a disability who may be entitled to Section 504 services, a student must meet all 3 parts of the disability definition. The disability definition also includes someone who has a record of having such an impairment or is regarded as having such an impairment. Students who have a record of having an impairment or who are regarded as having an impairment are not eligible for FAPE or Section 504 services, but are prohibited from discrimination on the basis of disability.
So Loni, do you mean some students without an IEP or 504 plan in place still have some protections?
Yes. For example, if a student was mistakenly considered to have AIDS, he or she would be prohibited against discrimination based on that false assumption. However, the student would not be eligible for any services because he or she would not actually have a disability. Diana, could you explain the rest, please?
Sure. The Office for Civil Rights, OCR, has also further defined the definition of, quote, qualified student with a disability by adding that a protected elementary or secondary student must be one of 3 things. 1, the age at which students without disabilities are provided elementary and secondary educational services. 2, the age at which state law mandates elementary and secondary educational services to students with disabilities. Or 3, a student to whom a state is required to provide a free appropriate public education under the IDEA. This would mean that if a state provided universal preschool services to all students, that preschoolers with disabilities would be protected by Section 504. Next slide.
Under Section 504, an impairment is a physiological condition that affects a bodily system. The precise definition of physical or mental impairment from the Section 504 regulations is A, any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, including speech organs, cardiovascular, reproductive, digestive, genitourinary, hemic and lymphatic, skin, and endocrine, or any mental or psychological disorder such as mental retardation, organic brain syndrome, emotional or mental illness, and specific learning disabilities. Section 504 does not provide a list of specific diseases or conditions that qualify as an impairment.
Some examples of disabilities that may qualify a student for services through Section 504 include, but are not limited to, cerebral palsy, epilepsy, muscular dystrophy, multiple sclerosis, cancer, diabetes, heart disease, HIV/AIDS, dyslexia, dysgraphia, rheumatoid arthritis, attention deficit hyperactive disorder, cystic fibrosis, severe allergies, and asthma. Isn't this right? I guess it's important to note the sentence, not limited to.
Yes. Also, having an impairment is only the first part of qualifying under Section 504 as a student with a disability. The next few slides outline additional requirements that the impairment must substantially limit one or more major life activities. Next slide.
That term seems important. Substantially limits. It must be defined in the Act.
In fact, it is. The second part of the Section 504 disability description, or definition, is substantially limits. The term substantially limits means more than materially limits, but less than severely limits. In order to determine the level of limitation, one should consider the condition, manner, and duration of the impairment, the nature of the impairment, the severity of its impact on an individual, and the expected length of time the impairment may affect the individual must all be taken into account.
Does this mean, for example, an allergy that causes a rash would probably not be considered substantial, but an allergy causing anaphylactic shock likely would, Loni?
Yes. The ADAAA clarified two important points that broaden and help to clarify the definition of the disability under Section 504. The first point relates to mitigating measures. Mitigating measures are factors that decrease the impact of a disability, such as medications, hearing aids, prosthetic limbs, and other aids used to manage an impairment. Before the ADAAA, mitigating measures were considered when school districts determined whether or not a student had a disability. For example, if a student with diabetes effectively managed his or her condition with insulin, she would not be considered to have a disability. The ADAAA, however, states that a disability determination should be made without looking at how the impairment is affected by measures made to lessen its effect. Examples of mitigating measures, according to the law, are assistive technology, reasonable accommodations or auxiliary aids and services, learned behavioral or adaptive neurological modifications, and prosthetics. The only exception is the use of ordinary eyeglasses or contact lens. Dianah, could you review the second point, please?
Sure. The second point clarified by the ADAAA is that conditions that are episodic in nature or in remission can still be considered as a qualifying impairment if they result in a substantial limitation when they are active. Examples of conditions that may meet this criteria include cancer, epilepsy, and depression. Next slide.
The third and final part of the definition of disability under Section 504 is that the impairment must substantially limit a student's ability to perform a major life activity. Major life activities are things that are essential for daily living. Both the Section 504 regulations and the Americans with Disability Act Amendment Act list examples of major life activities, but they are not meant to be exhaustive.
I noticed that the list on the right shows how the ADAAA expanded the definition of disability by broadening the type of major life activities. This means that students who did not previously qualify for Section 504 protection may now be eligible because of the expanded definition of major life activities. Next slide.
The Americans with Disabilities Act Amendments Act further broadened the definition of disability by adding a list of bodily functions that could be considered as a major life activity. Again, this list is not exhaustive. Dianah, could you explain how this list can be helpful?
Sure. The inclusion of bodily functions may be especially helpful for students with medical conditions such as diabetes, epilepsy, Crohn's disease. The ADAAA clarification of the disability definition may help students with disabilities related to these bodily functions have their individual educational needs met. Next slide.
Okay, review time. Dianah, what's the name of the law that includes Section 504?
All right. Anybody out there know the answer? All right. Section 504 is part of the Rehabilitation Act of 1973.
And what are the three parts of the definition of disability under Section 504?
All right, everybody out there, think ahead, see if you know this also. Section 504 defines person with a disability as a person who, 1, has a physical or mental impairment, 2, that substantially limits, and the third part is a major life activity. It also includes someone who has a record of such an impairment or is regarded as having such an impairment. Next slide. Loni, I was wondering about private schools. What is their responsibility?
That's a good question. 504 also applies to private schools that receive federal funds, such as for textbooks, school lunch programs, etc. The purpose of civil rights laws, such as the Rehabilitation Act, Section 504, is to prevent discrimination and guarantee equal opportunity. Section 504 ensures that through an individualized process that qualifies students with disabilities, that they have equal access to education.
So what about grades? Can a student 504 plan state the student will earn A's in a class?
No, Section 504 does not guarantee that students with disabilities will achieve certain results, example, A grades in classes. According to Section 504, public schools must provide a free, appropriate public education, also known as FAPE, to qualifying students with disabilities. The first part of the FAPE definition is free. Parents cannot be charged for additional services or accommodations that are needed because of a child's disability.
Loni, parents need to also know that they can be charged fees that are paid by all students, such as activity fees. Next slide. Now about what is an appropriate education. According to the Office for Civil Rights, there are 4 main components to ensure that a student's education is appropriate. Loni, can you explain this to us?
Of course. This means that 1, the needs of the student with a disability must be met to the same extent as students who do not have disabilities, even if the school must provide additional services, supports, modifications, or accommodations to meet their needs. An appropriate education can be provided through regular education, special education, related aids, or related services.
Also, 2, it is important to note that this does not mean that students with disabilities will receive the best education possible, but only that the quality of education service provided will be the same as what is provided to non-disabled students. This also includes equal access to non-academic services provided by the public schools, such as extracurricular activities, after-school programs, athletics, transportation, and health services.
And number 3, students with disabilities should be placed in the regular education setting with their non-disabled peers, unless a student's needs cannot be adequately met in such a placement, even with the use of related aids and services.
And 4, an individual evaluation conducted by the school must be used to ensure that students are properly classified as having a disability and receive the proper placement.
And 5, an appropriate education also means that proper safeguards are in place and known by the parents, so parents can appeal decisions through a specific process. Next slide.
On this slide, we see a teenage girl carrying books between library bookshelves. Next, we will be overviewing the following points. The following processes are used to ensure that schools provide qualified students with disabilities with an appropriate education. Not all schools implement each step in the same way, but the overall process is similar for referral for evaluation, the evaluation, eligibility determination, developing the 504 plan, reviewing the plan, and conducting reevaluation. Next slide. Loni, could you explain what the evaluation process needs to consider?
Yes, it's important that teachers, counselors, and other staff know that, like IDEA, Section 504 requires school districts to identify and evaluate students who are suspected of having a disability. School staff should refer a student for evaluation if they suspect the student has a disability and may benefit from Section 504 or IDEA services.
Parents may request a referral for evaluation under Section 504 for a variety of reasons. They may know their child has a disability, but the student was found ineligible under IDEA. The student may be struggling academically or in danger of being retained. A parent may also request a 504 evaluation if they have revoked consent for special education services under IDEA. A request for evaluation should be made in writing to the school's Section 504 coordinator.
Also, parental permission is required, whether the school or the parent initiates the evaluation or referral. Permission from the parents must be obtained in writing before an initial evaluation can be conducted. It's important to know that after a parent requests an evaluation, the school may either proceed with the evaluation or refuse the request to evaluate. If the school does refuse the request to evaluate, it must provide parents with a notice of their procedural safeguard rights so that parents know of their opportunities to appeal the decision or proceed with an independent evaluation. One tip for you is to be sure to list all areas of concern in your letter when you are requesting an evaluation, and include the need for assistive technology consideration if you feel it may be required. Next slide.
There's a photo of a teacher helping a student with her desk work. We are learning that there are many reasons why a proper evaluation is required as part of the 504 process. Even students who have medical diagnoses must be evaluated to determine if they have a qualifying disability under Section 504. Data from the evaluation also helps the team make service and placement decisions based on students' individual needs. Next slide.
Section 504 regulations require school districts to establish standards and procedures for conducting pre-placement evaluations for students suspected of needing special education or related services, as well as for required periodic reevaluation.
The procedures developed by the school must ensure that the following criteria are met. Tests and other evaluation materials must have been validated for the purpose they are being used. This means that the tests have gone through a process to ensure that they measure what they are supposed to be measuring. Additionally, the person conducting the test must be trained to administer the test correctly. Tests must address all potential areas of need, not just intelligence. Tests must accurately reflect a student's achievement and aptitude in the area being measured and not be biased against students with sensory, manual, or speaking impairments. Evaluations must be completed in a reasonable amount of time. The 504 regulations do not provide specific timelines, but OCR has interpreted this to be similar to requirements under IDEA, which requires the initial evaluation to be conducted within 60 days of parental consent. State requirements may be different.
What about if the student speaks another language?
Then the test should be delivered in the child's native language.
You should also know that the 504 regulations don't provide detailed requirements for periodic reevaluation of students served under Section 504, but they do note that a procedure consistent with IDEA would be one way of a district meeting this requirement. IDEA requires reevaluation at least once every 3 years. Next slide. Parents may wonder whether a medical diagnosis is required to qualify a student for Section 504 services if they have a disability such as ADHD. According to the Office for Civil Rights, a medical diagnosis is not required. If the 504 team determining a child's eligibility believes a medical diagnosis is necessary as part of the evaluation process, then it must be conducted at no cost to the parents. Students who have a medical diagnosis do not automatically qualify for Section 504 eligibility. However, that information must be considered by the team making eligibility decisions. Next slide.
Once students are determined to be eligible under Section 504, they must be reevaluated on a periodic basis. Periodic reevaluation is not defined in regulations, but school districts may use IDEA procedures as one way of meeting this requirement. Under IDEA, reevaluations must be conducted at least every 3 years, and more often if requested by the child's parent or teacher. So Loni, do 504 plans expire?
Although there's no expiration date for a 504 plan, periodic reevaluation ensures that the student needs are being adequately addressed. Because a student's 504 plan should be based on evaluation data, reevaluations must occur before any significant change in placement. Dianah, why don't you explain what that term placement means?
Sure. According to the Office for Civil Rights, this would include transferring a student from one type of program to another, terminating or significantly reducing a related service, or excluding a child from his or her educational program beyond 10 days. This may include a series of suspensions that total more than 10 days, even if each individual suspension is less than 10 days, because it creates a pattern of exclusion.
I see we have no questions, so unless anybody has a question, we're going to continue on. We have a lot of information to cover. Is there anybody that has a question? Okay, we're going to continue to the next slide.
There will be time at the end to ask questions too, so if you do think of questions, you can certainly write in the chat box and we'll get to that at the end. So who is on the 504 team? After the pre-placement evaluation is conducted, a 504 team should meet to 1. Determine whether the student is eligible for Section 504 services, and 2. Consider the placement options. Section 504 regulations state that the team should be composed of people who are knowledgeable about the student, and also understand the meaning of the evaluation data and the placement options. Parents are not specifically required to be members of the team as in IDEA, but as people knowledgeable about the child, OCR has stated that the school should provide parents with the opportunity to participate in team meetings and decisions. Next slide.
When determining whether students are eligible for Section 504 services and what type of services they should have, the team should also document and consider information from a variety of sources. In addition to any standardized achievement or aptitude tests, the team should also take into account information provided by the child's teacher, doctor, and other service providers, and of course, parents. If parents obtain an independent evaluation of their child at their own expense, That information should also be considered by the team when making their placement decisions. A little tip for self-advocacy: also consider student input and participation.
That's right, Loni. It is important that the team consider information from these various sources to ensure a student's 504 plan is based on his or her individual needs and not any assumptions about the child's disability. If the team decides the student is eligible for 504 services, the team will next decide on the child's accommodations or services. This is collectively referred to as the 504 plan. If the team decides the student is not eligible, the parent must be provided with an explanation. The parent can appeal the decision through a hearing in the district. Next slide, please.
There's a photograph on this slide of some students at their desk in a classroom. Schools must develop a 504 plan for eligible students that describes the services and accommodations that will be provided to the child. The plan should also include where the services will be provided and by whom, although it may not note the names of the individuals, but perhaps the qualifications. Section 504 regulations do not require that a 504 plan be written, but it's best practice. A written plan allows all parties to be clear on what has been agreed to and provides parents with adequate notice of the team's decision. Additionally, those responsible for implementing the plan will know what is required of them. And Dianah, is there anything else you'd like to add?
Yes, thanks. The plan should also include a communication plan so the parent knows how that information will be communicated to everyone who works with the student, including staff, such as lunchroom aides and school bus drivers. Next slide. In general, a student with a 504 plan may be placed in 3 possible settings. 1 could be the regular classroom, 2, regular classroom with supplemental services, or 3, in a special education program with related services. The presumption of the Office for Civil Rights is that school districts should place students with disabilities in the regular classroom environment with their peers without disabilities, unless a student's individual needs cannot be met in such a placement, even with the use of supplementary aids and services. Supplemental and related services, which will be described in more detail later, include things such as testing accommodations, preferential seating, tutoring, counseling, and assistive technology.
Dianah, it's important to note that part of providing FAPE to students with disabilities under Section 504 may be through the provision of special education services. Students found eligible under Section 504 can receive special education services even if they have not been determined to be eligible under IDEA or special education. The most important factor to consider when determining the educational setting for students with disabilities under Section 504 is inclusion. Even if a student needs to be placed outside the regular classroom in order to receive FAPE, the team must consider the proximity of the alternative placement to the child's home. One other thing you should know is that occasionally students are placed on home instruction for a variety of reasons due to medical conditions or mental health conditions, and a plan is made to return them to the regular school setting as soon as possible. Next slide. This slide provides some examples of accommodations that may be provided through Section 504 plans. This list is not meant to be exhaustive. Plans should be very specific in their description of supplemental services. For example, if extended time is provided as an accommodation, how much extra time and under what circumstances? Removal of physical barriers, extended time for testing, adjustment of class schedule, rest periods, use of aids or technology such as calculators, recorders, note takers, modified textbooks, etc. Individualized homework assignments.
Note that mitigating measures such as hearing aids, medications, or other ways used to alleviate the impact of a disability cannot be taken into account when determining whether a student with a disability is eligible for 504 protections. However, they may be considered when determining what services are needed to meet the child's individual needs. Next slide. This slide shows a photo of a person's fingers performing a pinprick glucose test. In addition to accommodations, related services may also be part of a student's placement and 504 plan. This list is not exhaustive again. What is most important to remember is that a 504 plan must be based on a child's individual needs to ensure the student's needs are met as adequately as students without disabilities, and that the student is provided with a free, appropriate education in the least restrictive environment. Loni, can you please explain the definition of related services?
Sure. Related services, as defined by IDEA, is a term used in the public school setting to refer to developmental, corrective, and other supportive services, including transportation. It's important to note that related services may include health services that do not need to be overseen by medical personnel, such as the administration of medication or glucose monitoring and insulin shots for students with diabetes. Because health services are a type of related service that may be needed by a student to receive FAPE, schools should not require parents to come to school to administer medication needed by their children. Next slide.
Section 504 does not just protect students with disabilities from discrimination in educational settings. The regulations also require equal access in non-academic programs run by the school district. Examples include, but are not limited to, before and after school programs, field trips, extracurricular activities and athletics, career and guidance services, and transportation. For example, schools that provide career counseling must ensure that students with disabilities are not guided to more restrictive career objectives, but receive the same opportunities as non-disabled students with similar interests and abilities.
That's good to hear. Schools providing athletic programs for students must ensure students with disabilities have an equal opportunity to participate. Different services can be provided to children with disabilities if the school district provides students with disabilities an equal opportunity to compete for interscholastic teams. Extracurricular programs can require participants to have a certain skill level to participate. Advanced placement or AP classes, or band, or sports, as long as students with disabilities are not excluded simply because they have a disability and may need accommodations or related services. For example, a student with a disability must be otherwise qualified or have the necessary athletic skills to participate on a varsity sports team. You can click on the link on the slide to read the guidance letter from the Office for Civil Rights. Next slide. Let's see what you've learned. Do you remember the 6 steps?
The 6 steps in the 504 process are 1. Referral, 2. Evaluation, 3. Eligibility determination, 4. Development of 504 plan, 5. Review of the 504 plan, and 6. Re-evaluation.
Membership is not prescribed as far as who would be on the 504 team, but who may be included as potential members of a 504 team meeting.
On that team, you may have a 504 coordinator, a psychologist, social worker, teacher, parent, nurse, other school staff.
Or even the principal. So there's no timeline in Section 504 law or regulations other than reasonable. OCR states that the IDEA timeline of 60 days or a state-specific timeline may be used. Next slide.
All right, procedural safeguards. Procedural safeguards is a term for actions a school must take to ensure that a policy is implemented correctly and fairly. Procedural safeguards are a way to guarantee that parents know what is going on with their children's education and that there is a system for them to voice a disagreement about the school's decision. Section 504 requires that schools' procedural safeguards include the following components: notice, opportunity for record review, impartial hearing process, and a review procedure. Section 504 does not provide detailed requirements for these provisions. However, the regulations state that following the procedural safeguards provisions of Section 615 of the IDEA statute is one way of meeting this requirement. The procedural safeguards in IDEA provide further protection and detail than what is provided in Section 504 alone.
Notice. Parents must be informed of actions taken by the school regarding the identification, evaluation, and placement of their child with a disability. This is called notice. Section 504 does not specify that this notice must occur in writing, but that is considered best practice.
Record review. Parents must have the opportunity to review the educational records of their child upon request. They have 5 business days to provide a copy of the record if the parent requests in writing.
In California.
In California.
Due process hearings. When there is a disagreement between the school and the parents regarding the student's identification, evaluation, or placement, the parent can request a 504 hearing. These impartial hearings are often referred to as due process hearings. Parents must be allowed to participate and be represented by an attorney if they so choose. Schools are not required to provide the parent with an attorney, however. Some states and districts use IDEA hearing officers for 504 hearings, while others may use someone else identified by the school. Section 504 does not specify any timelines for when hearings must take place, but if not specified by state law, the Office for Civil Rights has generally used IDEA case law for determining appropriateness. IDEA requires due process hearings to occur within 45 days of the end of a resolution period. Mediation is not an option under Section 504 unless states allow parents to use their IDEA mediation procedures for 504 disputes.
Review procedure. A review procedure simply means that the school district must have a system for evaluating its own compliance with Section 504. Next slide.
In addition to procedural safeguards, Section 504 also requires that school districts designate a 504 coordinator and adopt grievance procedures. Sometimes due process or impartial hearings are confused with grievance procedures, but they are not the same. While due process and other procedural safeguards specifically relate to providing FAPE to qualified students with disabilities, grievance procedures address more general concerns about disability discrimination.
Hi, sorry, this is Shannon. There's
So
a
grievance
question from
procedures
Dianah.
must be established
I'm not sure
according to the
if
Section 504 regulations
Dianah would like to
that
answer
apply to all recipients of federal funds with 15 or more employees. Okay, let's take a look.
The question is, when would you say it would be appropriate to consider taking a student off of a 504 plan and moving him or her to an IEP? For example, let's say a student has a 504 plan for motor disorder and receives OT and physical therapy via the 504 plan. You could classify the student under IDEA as other health impaired. How do you determine if the 504 plan is appropriate or whether the change should be made to the IEP?
That's an excellent question. Remember that eligibility and the referral process could be initiated by the parents or the student asking the parents to write a letter to the school district requesting an IDEA assessment so that an IEP team could consider whether the child meets one of the 13 eligibility criteria. I guess as a rule of thumb, if a Section 504 plan is not adequately providing the supports and services and accommodations that would allow equal participation and benefit educationally for the child, that would be a time at which I might consider sending a letter to the school district asking them to reevaluate under IDEA. So now we're going to get back to the slide. Dianah?
Sure. Okay. So talking about the grievance procedures, according to the regulations, school districts must do these two things. One, designate a responsible employee to ensure 504 compliance. This person is often known as the 504 coordinator. Or two, adopt grievance procedures that incorporate appropriate due process standards and provide for the prompt and equitable resolution of complaints alleging discrimination on the basis of disability under Section 504. Such complaints might involve disability harassment, differential treatment, or a lack of accessible facilities or programs.
I see that there is an additional question. I'm going to ask that we hold that and address that at the end of the training so that we can get through all the material today. And thanks for asking. Additionally, districts should notify parents and students through the district website, student handbook, and other relevant publications about who the 504 coordinator is and how to contact the coordinator, where to obtain a copy of the district's grievance procedures, and how to file complaints. Districts have the responsibility to adequately conduct an impartial investigation of complaints in a reasonable time frame. Districts also have the obligation to respond to disability-related discrimination allegations, even if a formal grievance complaint is not filed.
Also, parents have the right to ask at any time who the 504 coordinator is and to see a copy of the grievance procedures. The 504 coordinator may be an assistant principal, guidance counselor, or other school staff, including the principal.
If parents are not satisfied with responses received through due process or a district-level complaint, there are additional actions they can take. And you should know that there is a photograph on this slide of a court building on the right-hand side. To file a complaint with the Office for Civil Rights, parents or others should contact the appropriate regional office. The link is on the slide, The Office for Civil Rights primarily reviews cases resolving compliance with the proper Section 504 procedure. Complaints must be filed within 180 days of when the discrimination allegedly occurred. Complaints may be filed by an individual or organization and address discrimination against just one child, a group of students, or systemic issues. OCR will administratively close a filed complaint if it is also filed with another federal, state, or local civil rights agency or through an internal grievance procedure.
OCR will investigate the complaint through data collection and possibly an on-site review. In individual complaints, an informal process called early complaint resolution is an option. After the investigation, OCR issues a letter of findings that states whether or not there was a violation, and, if so, what the corrective actions should be. If school districts do not implement the needed changes, OCR can initiate proceedings to suspend or terminate federal financial assistance, or can refer the case to the Department of Justice. There is no timeline requirement for when OCR must issue a letter of findings. Parents can also go immediately to federal court. Parents are not required to exhaust administrative remedies before filing in federal court, as they are under IDEA. Attorney fees may be recoverable. Next slide.
School districts, families, and students as well should be aware that Section 504 includes anti-retaliation requirements, and therefore school districts cannot engage in an adverse action such as retaliation, threats, or intimidation against any individuals who assert their 504 rights or vocally oppose disability discrimination. Click on the link to read a memo about protections from retaliation from Disability Rights California and a Dear Colleague letter from the Office for Special Education Programs. It will help you understand your protections. Next slide.
There's a photo of a mother with an ill child on this slide. What are the 4 types of procedural safeguards in Section 504? 1, you have notice. 2, a records review. 3, due process or impartial hearing. And 4, review procedure. Next slide.
The photo on this slide is of some notebooks and some markers put on top of them. The next several slides provide examples of accommodations, modifications, and related services that may be provided to students with various disabilities under a Section 504 plan. The lists are not meant to be exhaustive or prescriptive, as each 504 plan should be developed based on the unique needs of the individual student. However, these slides provide examples for parents to consider as they develop their own child's 504 plan. Click on the link on the slide to view a listing of possible accommodations. Next slide. Okay, what can be done for a student with ADHD?
Students with ADHD may need supports to help them stay organized and focused. Children may need extra time to complete their work, shorter assignments, extra books so they can have one set at home and one at school, a quiet testing environment, and supervision on field trips to help them with their impulse control. The particular services and accommodations needed by a student with ADHD may vary significantly from child to child. Assistive technology can also be considered to provide access to the curriculum or to assist with the executive function deficits of the student or to provide access in some way.
Next slide. Next slide. What about a child with diabetes?
Students with diabetes may need assistance with monitoring their blood sugar levels and injecting insulin. Even students old enough to manage their diabetes themselves may need access to a private room to monitor their glucose. Children with diabetes may also need the opportunity to make up for tests or instruction missed due to their illness.
Students with diabetes may also need an individual health plan that outlines what response should be taken if their glucose is too high or too low, and that ensures that trained staff are present at school and on field trips as part of their 504 plan. Next slide. What about the child that has severe food allergies? Students with allergies are becoming more common now.
A child with severe food allergies may need accommodations to avoid contact with the allergen and a plan to ensure staff are trained in the event of an emergency. Students may also need to store snacks at school so they are available for special occasions such as birthdays or class parties. Additionally, the student may need someone to assist in the administration of medication. There may need to be training of staff to recognize signs of reaction and medication administration. Next slide. What about children with learning disabilities?
Well, a child with a learning disability may need some basic accommodations to ensure equal opportunity to access the general curriculum. Some examples of related services and accommodations that may be included as part of a 504 plan are note takers for class lectures, shortened homework assignments, assistive technology such as audio textbooks, or extended time for test or testing in an alternative location. Next slide.
What about for children with anxiety disorders? Don't those children sometimes have another diagnosis they may need support for?
True. Children with anxiety disorders may need some accommodations to help them decrease their level of stress in the school environment and help them stay focused. The following related services and accommodations may be included as part of a 504 plan, such as extended time, supervision of the administration of medication, time for appointments with counselors and perhaps a peer note taker while the student's out, a modified schedule, or the ability to take breaks when needed in a quiet area. Next slide.
And as an example for a student with arthritis, may need accommodations to allow for movement throughout the day to avoid a stiffening of joints. The student may also need assistance with carrying heavy objects and alternatives to writing with a pencil, including assistive technology. Children with arthritis may also need assistance with administration of medications during the school day, or need a peer note taker. Next slide. Loni, should we open for questions?
Okay, let's do that. So I see that there was an additional question that someone wrote in. Can you expand on educational benefits? So I wanted to make you aware that Section 504 is an access law, and since this child if the child is under Section 504 and you have concerns that the 504 plan is serving the child and creating educational benefit and they're suffering academically, it's certainly an option for you to go ahead and make a written request to the school district to do an IDEA or special education evaluation. And then in California there is a 60-day, or there can be no longer than a 60-day assessment timeline if the district agrees to assess the child. I think it's very helpful both under Section 504 and IDEA that parents are careful to include all of the educational and other functional concerns that they have about their child in school, and when they write their reasons for making that referral for assessment. That gives the school staff an opportunity to include all the different areas of assessment that need to be completed. And I hope that answers your question. Do we have any other questions today?
So one thing about the previous question, it mentioned that considering switching away from the IEP to a 504. Remember, we did mention there were
off of 504 and moving to an IEP.
Okay, so remember that so even if deciding which plan you want to prioritize to pursue, sometimes parents are trying to debate, should I so-called go for a 504 or go for an IEP for my child. Remember that a 504 plan doesn't have any state funding that funds the supports and services. So that's one thing to consider. So if your child may need to consider supports and services, an IEP might be an area that they could qualify for special education and related services, and then the school would receive funding to provide those supports for.
Now I want to continue and tell you a little bit about some of the links that we included as resources for you so that you'll have access to some of the frequently asked questions and answers from the Office for Civil Rights. This slide has the frequently asked questions. That's a wonderful link to download and take a look at. And then Wisconsin Faucets, another parent training and information center, has published their slideshow on Section 504, and it's a wonderful slideshow well worth looking into. And I'm going to go to the next slide.
Did you get a chance to ask the other questions about what if?
Oh, I see. There's another question. Yeah, I see. There's another question here. It says, what if the assessment plan that the district provides does not consider all areas of concern? Well, if the assessment plan is either under Section 504 or under IDEA, parents can always object, and you have procedural safeguards and a process for you if you are in disagreement with the district, with what the district is providing. Sometimes parents write a second letter, and they're more compelling in their second letter and put more expansive description of the reason why there needs to be assessment in those areas that the district didn't at first put into the assessment plan. And then parents can always consent with their exception and put down that they don't feel that the assessment is going to adequately address the areas of need that they think the child has, and then use the procedural safeguards under OCR if it's 504, and through the state complaint system, possibly if it's through special education, although this training is focused on Section 504. Are there any other questions? So going back to the slide, I've given you the link. We put the link to the National OCR headquarters here because you'll see on the last link of the training, it lists all the different regional offices so that you have an option to contact them. They usually have someone called the Officer of the Day, Monday through Friday, available to talk to parents and professionals and answer questions. And let's say 504 complaints can be filed online or can be done in paper and sent through the mail system. So there is a link there to the complaint information that gives you those options. And do we have any other questions today? We hope that anyone that has any unanswered questions will direct them to our agency. We're a federally funded parent training and information center. We would love to refer you to the one that's closest to you, and we'd like to get you information related to any additional questions that come up following this training. And thank you so much for attending today.
And thank you so much, Loni and Dianah, for presenting today's on Section 504. We'll have more. They'll be presenting again next month, and hopefully on IEP, hopefully you will be able to join us then as well. The announcement will be sending out very soon. Thank you so much for all those who came today. Have a good day. Bye.
Thank you. Bye. Thank you.